So welcome to today's panel discussion of Judge Amy Coney Barrett and the Supreme Court confirmation process. And I am delighted to briefly present to you, my colleagues. I am joined here by Professor Matt Coles, who not only is an eminent graduate of UC Hastings, a proud alum, but was also, before he joined Hastings, our faculty, the Deputy National Legal Director of the ACLU. He was one of the lead attorneys on Romer v. Evans. So proud to say I know one of the lead attorneys in that landmark Supreme Court decision that paved the way for Lawrence v. Texas and Obergefell and same-sex marriage. And I'm also joined by my eminent colleague, Professor Rory Little, who is the Joe Kochett Professor of Law. And he is a renowned Supreme Court watcher. He writes about US Supreme Court cases for SCOTUS blog. And he clerked for not just one, but 4 Supreme Court justices. So we have a great panel on board for today to talk about the Supreme Court and Judge Barrett. Who is Amy Coney Barrett? Well, just a few
Professor Rao, are you going to tell them who you are? Professor Rao clerked as well for Justice Thurgood Marshall and Justice Harry Blackmun, and is a renowned international authority on various constitutional and legal issues.
Thank you, Rory. It's always a little awkward to introduce oneself. So I was going to just briefly begin by saying that Amy Coney Barrett, Judge Barrett, I should say, currently is a judge on the United States Court of Appeals for the 7th Circuit, based in Indiana. She was born in New Orleans, Louisiana. She attended Rhodes College. Then she attended law school. She studied law at Notre Dame Law School, where she graduated #1 in her class on a full tuition scholarship. After graduation from Notre Dame, she clerked for Judge Lawrence Silberman on the United States Court of Appeals for the District of Columbia Circuit, and then clerked for Justice Scalia on the US Supreme Court. She was a law professor. After her clerkships, she joined the law faculty. She spent a few years in practice. I think Rory will tell us a little bit more about that. But then she became an academic. She joined the law faculty at Notre Dame, where she taught federal courts, constitutional law, and statutory interpretation. Judge Barrett is, of course, was appointed to replace the vacancy that was left by RBG. But Judge Amy Coney Barrett is clearly no RBG. What can I say about Judge Barrett? I was going to speak a little bit about her position on Roe versus Wade and the abortion question, since that is my area of constitutional expertise. So with respect to Roe versus Wade, what can we say about Judge Barrett? Well, she refused to answer questions on Roe versus Wade, even though her position on the issue of abortion seems pretty obvious. She signed a letter in the South Bend Tribune that criticized Roe and called it a barbaric legacy. And she delivered a lecture to the Right to Life Club at Notre Dame Law School and even joined an anti-abortion faculty group. Full disclosure, I should probably confess that I have signed a letter, a law professor's letter, urging senators to vote against Barrett's confirmation to the Supreme Court. So I too have signed a letter. What did Judge Barrett, what did she say about Roe? Well, she apparently said that Roe is not a super precedent. But that other constitutional cases do deserve super precedent status. And specifically, she referred to Brown versus Board of Education as a super precedent, one that everyone agrees should remain the law, should never be overruled. But she suggested that the very controversy that Roe had raised and the number of questions that she'd been getting about Roe suggested it was not a super precedent. I wasn't surprised that Judge Barrett refused to comment on Roe versus Wade. However, I must confess that I was actually surprised that she refused to approve even such an uncontroversial decision as Griswold against Connecticut, the 1965 Supreme Court case in which the court upheld the right of married couples to use contraceptives. Even conservative jurists like Charles Freed, a former Solicitor General for the United States, who argued that Roe should be overruled. He was one of my constitutional law professors at Harvard, and he has suggested that Griswold is obviously good law. Chief Justice Roberts commented on and suggested in his confirmation hearings that he agreed with Griswold against Connecticut. So it's kind of shocking that Judge Barrett would refuse to comment on a case as uncontroversial as Griswold against Connecticut. Now, many people have referred to these confirmation hearings themselves as really a kind of a spectacle, a meaningless spectacle, you might say, full of sound and fury, signifying nothing. What's the point of confirmation hearings, some have asked, if all of the votes are already predetermined? But I think that on one level, I would agree, this confirmation process really does seem like a charade. At another level, I think it's important to listen to Judge Amy Coney Barrett, and we can learn volumes about her, both from what she said and what she didn't say, such as her revealing refusal to comment on Griswold against Connecticut. I was even more astonished, I must confess, by Judge Barrett's surprising use of the phrase sexual preference to refer to LGBT people. As a smart woman, obviously, graduated #1 in her class at Notre Dame, and a former professor of constitutional law, how could she be unfamiliar with the appropriate terminology? As far as I know, there's no constitutional law casebook that refers to sexual orientation as sexual preference. So whether that was a mere slip of the tongue or evidenced a mindset on her behalf, that it seemed to suggest that Judge Barrett believes that that sexual orientation is a choice, that it's a mere matter of preference, and that people can not a part of somebody's identity, and that people can choose the sex of the person they love. Lastly, what else can we say about Judge Barrett? Well, specifically on the issue of abortion, even though she didn't speak about Roe versus Wade, I should note that as a judge on the United States Court of Appeals for the Seventh Circuit, she joined a really important dissent from a denial of a rehearing en banc in an abortion case that passed upon the constitutionality of an Indiana law, which, by the way, was signed by then Governor Mike Pence, currently the vice president. When he was governor of Indiana, he signed this law, which contained two provisions that were at issue in the case. One of them barred abortions for purposes of choosing the race, sex, or disability of a fetus. They made it illegal if the reason for a woman's abortion was based upon race, sex, or disability. And the other provision of the Indiana law required burial or cremation of fetal remains. The United States Court of Appeals for the Seventh Circuit, the panel that heard that case, the judges ruled that both provisions of the law were unconstitutional. But the full court wanted to hear the case en banc, but they couldn't get the necessary votes. So basically the Seventh Circuit was split by an even number because one judge recused himself. And so they didn't hear the case en banc. Dissenting from the court's denial of the rehearing en banc, Judge Frank Easterbrook wrote a dissent, which Judge Barrett joined. And that dissent argued that the case should be reheard en banc because a law that prohibits abortions for specific purposes is not governed by Planned Parenthood against Casey. Judge Easterbrook made that argument, and Judge Barrett was willing to sign his opinion. That's a pretty frightening interpretation of Planned Parenthood against Casey, which suggests Planned Parenthood against Casey, of course, is currently the law of the land. And that is the 1992 Supreme Court decision in which the Supreme Court retained and reaffirmed what it called the essential holding of Roe versus Wade. So Planned Parenthood against Casey essentially says that if a law imposes an undue burden upon the abortion right, if it imposes a substantial obstacle, it should be unconstitutional. Easterbrook was arguing that a law that prohibits abortion for certain reasons is not governed by Casey, and Judge Barrett was willing to sign on to him. The other part of the holding was even more controversial. Essentially, the Seventh Circuit found the law, the fetal remains part of the law, unconstitutional because they thought it failed even rational basis review. But Judge Easterbrook disagreed with that provision, and the US Supreme Court ultimately agreed with him on that. Well, I'm going to leave the rest of my remarks because I don't want to speak too long, and I want to get to my other colleagues. But one last thing I wanted to say about Judge Barrett was that Judge Barrett said, if she's confirmed, we'd get Justice Barrett, not Justice Scalia. But I'm a little bit frightened because I fear that Justice Barrett could be even more radical than Justice Scalia. And so, some of the things that she said suggested, and I think you'll hear more from my colleagues on that point. So let me conclude, and I think Professor Coles is going to speak next.
Thank you, Radhika. I have to confess at the start, I didn't watch a moment of the hearings, and I'm not sorry. I think that the hearings that we've been holding are a complete farce. The notion that the Senate of the United States should decide if it's going to consent to the appointment of someone who will decide the constitutionality of Congress's acts, but that it was somehow unethical or improper for the Senate to find out how that person interprets the open-ended phrases of the Constitution, what due process of law means, what equal protection, just seems to me to be completely ridiculous. I think both parties are complicit in this. I think the Senate from this point on should refuse to confirm anyone who won't answer questions about what the open-ended language of the Constitution means. They don't have to answer questions about cases that are in the pipeline or that they know are going to come up, but that's very different than saying, here's how I think equal protection works. Judge Barrett actually told us more than I think recent appointees have. She told us that she's an originalist, and she explained that she subscribes to the currently fashionable notion of originalism, which isn't that we go looking for the original concept that these open-ended phrases contained, but that we ask, how would people in 1789 have applied that idea? Or in 1868, when the 14th Amendment was adopted, how would they have applied that idea? I think that's a self-contradictory and silly way of thinking about constitutional interpretation. It's self-contradictory because we know the people who drafted the document didn't intend it to work that way. They put general phrases into it, as we did in the 14th Amendment as well, into a document difficult to amend with the notion that it would endure and be usable throughout for much of the future to come. So they didn't intend that kind of an interpretation of the Constitution. And if you're an originalist, that's not what was originally meant. More to the point, in a way, it's not 1789 or even 1868. The internet, forget the internet. TV, forget automobiles. None of those things existed. We did have still photography, but that's about the end of it. And that's it at the time of the 14th Amendment. So the originalists say to us, well, we have to accommodate changes in technology. So we'll ask, what would a typical 1789er or 1868er have thought about the internet or television? That seems to me to be breathtakingly narrow-minded. We're going to take into account changes in technology, but not in human knowledge, not in the evolution of the human spirit. We're really going to ask, what did people think about Black people in 1868 or women in 1868? And take no account of everything we've learned in all the years since, but we'll take technology into account? That makes no sense to me whatsoever. The other problem with originalism is it tends to be very casual. I tend to, any true originalist would have to subscribe to the notion that the 14th Amendment was passed in order to empower Congress to create affirmative action for Black people. But that notion disappears when affirmative action comes up, and originalists tend to say, as John Roberts does, well, times have changed and a lot has happened, and so much for originalism when it isn't convenient. So my difficulty is, I think what she's told us is she's subscribing to a self-contradictory, relatively silly legal philosophy that simply doesn't work if your Constitution is going to be an enduring document and is going to continue to work. As people have, let's face it, she is almost certain to be confirmed. And so as people look at the potential confirmation, I've heard people asking, what are we going to do now as the federal courts are becoming political? I think that's the wrong question. The federal courts are already a political institution. That started to happen at least 11 years ago when the Senate decided to use every procedural block it could in the hopes that the then president would be a one-term president and wouldn't fill many vacancies. Used procedural blocks people hadn't used before. And then when they got control of the Senate, basically confirmed almost no one and created the one-year rule for Supreme Court appointments. And then when they got control and the presidency, threw out all of the procedural blocks they'd used before, said none of them were going to apply to judicial appointments, and got rid of the one-year rule, as we've just seen. It is a political institution. And the real question we ought to be asking is, what do we want from a federal court system recognizing that it is now the third political branch, that it is essentially appointed politically and people are being appointed on the basis of their political views? And I think the answer to that is as to 95% of what the federal courts do, there's not very much that we need to change, because 95% of what the federal courts do is not really driven heavily by ideologically, certainly by political ideology. We probably don't need to change much for most of that. But for that percentage of cases that really are driven intensely by political views, I think we ought to invoke at a minimum Article 3 of the Constitution, and that Congress should modify the appellate jurisdiction of the Supreme Court and modify the jurisdiction of the lower federal courts and say, if you want to declare an act of the other political branches unconstitutional, 3/4. So if you're attacking the constitutionality in the lower federal courts, we impanel a federal panel of 5, not 3, and it's got to be 4 if you're going to strike it down. And if we're at the Supreme Court, it's got to be 7-2. The people like me, and I suspect my colleagues who've spent much of their lives working in constitutional law, that might seem a little discouraging. It is discouraging for lawyers because in some ways the courts have been a great shortcut to the exercise of power in our society. But now that they are really political institutions, that kind of shortcut doesn't make sense anymore. And when you look at the court's history in context, the federal courts have not been a bastion of individual rights, and they have not been a strong force against oppression of minorities, against dissent, and what they have been, by and large, is a brake on progressive legislation. That's really the story of the court until the late 50s, and essentially, I think, since the mid 80s. So I don't think there's a great deal to lose there in terms of protecting individual rights. And I do think the institution as a political institution is much too huge a brake on the political process. And so I think it's time to cut back on the notion of a super judiciary in the political process. Thanks.
Radhika, my turn. All right, hi, I'm Rory Little. And what you're learning here is that law professors will use any excuse of specificity to tell you their general thoughts on lots of issues, and that's what we're going to do. I'm going to assume that many of you have seen at least clips of Amy Coney Barrett testifying. You have read something about the confirmation hearing. You are involved in today's issues, or you wouldn't have tuned in today. I see that we have about 130 people on this Zoom meeting and another 50 or more on YouTube. And I understand a lot of them may be alums. right? We may have alumni here. So I'm going to give alumni an introduction to today's Zoom classroom. Here's a slide called a PowerPoint, and this is the way we teach today when we're teaching remotely, at least some of us. I have 4 whole slides, maybe 5, in about 8 minutes. The plan is for us to speak in short chunks and then let you all ask questions and then come back and say things as those questions come to us. So I have this picture of the judge up here on the slide with a mask on when she's being sworn in on the first day, because to me it looks like she's being held hostage. And I agree with some of what Professor Cole said. I think she has been held hostage to this flawed and on this particular occasion completely illegitimate process, which is not to say that I think Amy Coney Barrett is a bad person. I don't know her, and from all accounts, she may be a very nice person. But this is not about her in any way, shape, or form. And in some sense, she is really held hostage and pretty much muzzled by the tradition of not answering questions that anybody cares about while she's up. Let me just say the history does not prohibit last-minute lame duck nominations or confirmations. The facts of Marbury versus Madison, for you alumni out there, I want you to have those sweet memories of Con Law 1. You know, the Federalists were packing the Supreme Court, appointing judges right up until midnight on the day the new president, the crazy radical Jefferson, was inaugurated. That's what the case is about. And John Marshall, who was one of those late-term nominations and confirmations, served as Chief Justice for another 34 years, I believe. But on this occasion, I think it's illegitimate, and that's because of the Merrick Garland thing. And you're all maybe familiar with this, but the Senate refused to give a hearing. We're talking about a hearing to Judge Garland. Why did they refuse to give him a hearing? They could have given him a hearing and then voted him down. But the reason they didn't give him a hearing is they didn't have the votes. They didn't have the votes to deny him the full vote on the floor, and they didn't have the votes to not confirm him on the floor. So they used their power at that time to withhold a hearing. And they all promised, including the chairman of the Judiciary Committee today, Lindsey Graham, that they would do the same thing if Trump were the president and this happened in his last term. This is, to describe this as anything other than a broken promise to the American people, and I mean all the people, is horribly hypocritical. That's the nicest thing I can say. I understand that today the Democrats have announced they're going to boycott the committee vote and just put up photos of people who will be hurt if the Affordable Care Act is overturned. And I think that's the right response. Why give it any legitimacy tomorrow? Because they know what the vote's going to be. What about next week's floor vote? I say next week because McConnell says he's going to bring it up as fast as he can. He wants to, just in case anybody gets COVID. They have to have their 50 votes on the floor, plus the vice president. If anybody's got COVID and can't come to the floor for some reason, this could fail. So it's not over until, it's over. And you've all heard various ways of putting that. What do we know about Judge Barrett and what don't we know? So Professor Rao went through a lot of things. She's got quite a stellar record in many ways. She did do 3 years of private practice at a firm called Miller Cassidy in DC, which is one of the greatest law firms in the history of American law, because I used to work there. But I wasn't there when she was there. I left a decade earlier. I was teaching at Hastings by the time she got to Miller Cassidy. She went on to clerk for a couple of judges. She clerked for Justice Scalia. She says, my philosophy is Justice Scalia's philosophy. And I agree with Professor Rao that I hope she's honest about that, because Scalia turns out to have been somewhat liberal in certain criminal procedure areas. He penned a case called Smith, Employment Division versus Smith. I'm one of the 3 people in the country that think that decision was correct. And the Supreme Court has been shooting to overrule it for years. I hope she sticks to her guns with Justice Scalia on that one. She is undoubtedly conservative, and I think someone should say she is devotedly religious. This is not something that she tries to hide. What that means, nobody knows. Justice Brennan was one of the more devout Catholics ever on the Supreme Court. He was on the court before Justice Scalia. They couldn't have disagreed more about what the sanctity of life might mean. Justice Brennan is a great supporter of the freedom to choose and against the death penalty 100%. Justice Scalia was exactly the opposite, both devout Catholics. So I would not put too much on this. How it's translated is important. We don't know a lot about her. There's a ton we don't know about her. She's never voted on lots of issues. She's never had a death penalty case. And justices don't always follow the path the president that nominated them want them to. This past summer, we saw the Supreme Court with 2 Trump nominees vote unanimously to enforce, or the subpoenas against the president's records at least could be enforced, both by a state as well as a federal entity. Future events also don't track what people expect, and justices don't always go over the arc of time, right? The Martin Luther King phrase, right? The arc of history. The important part about that phrase, the arc of history, is he said the arc of history is slow. The Supreme Court is slow. I don't agree with Professor Coles that the Supreme Court hasn't backed up certain individual rights over time, but it sure took them a long time to figure out what the 14th Amendment meant. It took them 150 years. It sure took them a long time to figure out that the First Amendment might apply to states' actions. But I have more faith, let's say, in the institutions, and I'm less willing to throw them over the side of the bridge than Professor Coles, but it wouldn't be any fun if we didn't have some disagreements. Let me just say that Justice O'Connor was the Republican appointee who ended up joining the opinion in Casey, which preserved the important right constitutionally of women to choose. Now, Casey limited the way that right is facilitated. It dramatically hurt particularly indigent women who would like to have abortions, and it's still not working the way it should. I think she'd be disappointed how it's working today. But at least Roe was preserved, and no one expected Justice O'Connor to do that when she was appointed. Justice Blackmun was Chief Justice Berger's best man at his wedding, and by 20 years later on the Supreme Court, they hated each other. So, you know, keep a good heart. Don't always say a new justice will do the bad thing, because I think that just encourages them to do the bad thing. Instead, tell them you have faith that they are capable of doing the right thing, and then see what happens. It doesn't always work. Somebody asked us to speak about textualism and originalism, and I'm going to show you that Matt Coles didn't invent what he said. In fact, what he said was by Chief Justice Marshall in McCulloch versus Maryland. Justice Elena Kagan said when she was delivering the Scalia lecture, we're all textualists now. And I think we're all originalists now. But we should be originalists in the way the framers intended the Constitution to originally operate. And McCulloch said it better. And Chief Justice Marshall was one of the framers. He was present at the framing. He was in the administration of the first Congress. It was the intention. What is original intent? It was the intention of the framers that the Constitution be adapted to future crises, which, if foreseen at all, could only have been seen dimly. And I always ask my con law class, why is the Air Force not unconstitutional? Because they didn't mention the Air Force. They said you have the power to raise a Navy and an Army, but no Air Force. Why didn't they mention the Air Force unless they intended that there be no Air Force? And certainly, we know the answer, right? There were no planes. They didn't think people could fly. A couple of issues here, not in any particular order. Let's just say if the Democrats were to win the upcoming elections, what could be done? First, a new Solicitor General could regulate to some extent the Supreme Court docket and not push issues that the current Solicitor General might be pushing, and try to withdraw the government support for other issues. That's one. Two, executive branch can take actions to moot some of the pending cases, such as the DACA case or the census case on excluding the undocumented from the census count. Third, if they actually were to win the presidency and both houses of Congress, Congress can enact legislation to fix various issues. For example, they could pass a new ACA. They could pass a new Section 5 of the Voting Rights Act. They could do various things to correct things we believe have been wrongly decided in the past. They can't get rid of a justice, But there are these proposals to strip the court of jurisdiction. I think that's what just Professor Coles was saying, or to expand the membership of the court. I don't call it court packing, I call it court expansion, put in term limits, and there's a lot of other proposals out there, such as the one you heard. And my only suggestion on this is if the Democrats take power, and that's a big if, it seems to me still, you better all vote. Wait and see is what I would say. Give it a little time. You don't have to do all that on January 21st. You can wait and see how things evolve. Again, the future may surprise us. Last thing, Judge Barrett, in a case called Cantor versus Barr, became a strong adherent of a Second Amendment right in the shoes, if you will, of Justice Scalia. And she did dissent from a majority view, but she did not say that all gun control was unconstitutional. In fact, she affirmatively said people who should not have guns can be prohibited from having guns by legislation. So she is not somebody who says, oh, I love to hunt and I love my guns. As far as I know, she doesn't hunt, but we'll find out. So what's my conclusion? There's my conclusion on the screen. The older alumni may recognize this figure, and I think we're now going to turn it back to Professor Rao. Radhika.
Wonderful. Thank you for those presentations. I just had a few comments. Rory, I love your slides. And on the felon question of whether people who've been convicted of a crime can be refused the right to bear arms, I thought that Judge Barrett's distinction was a really interesting one, where she drew a distinction between misdemeanors versus kind of, or more, less dangerous crimes, and people who've been convicted of a crime that involved violence or was viewed as more threatening. And she suggested that the framers would have permitted guns to be denied to people who were perceived as violent, who'd been convicted of a crime that involved some kind of greater level of threat, but that those who'd been simply convicted of a non-violent kind of an offense shouldn't be denied the right to bear arms. And in a way, that suggests that if we are going to permit people to have this right, at the very least, it shouldn't be denied to people in a kind of a discriminatory fashion. And so I guess you could consider that to be an encouraging development in Judge Barrett's jurisprudence. Also, with respect to the questions about originalism, both Professor Little and Professor Coles point out that originalism as a philosophy for interpreting the Constitution is internally inconsistent, right, and incoherent, because the framers didn't intend, their intention was that the Constitution should be adapted, that its words were deliberately broad. And so if the framers' vision of originalism is at odds with those modern day originalists, how is originalism as a philosophy itself even consistent or coherent? But I wanted to make a few points about textualism, which is another philosophy that Judge Barrett professes to adhere to. She says that she is a textualist, and a textualist applies the same kind of philosophy to a statute that an originalist, this is her argument, would apply to the Constitution. So she says that in reading a statute, we should stick with the original meaning of the statute. And based upon this philosophy, she wrote an article She wrote an article that actually was a review of Professor Randy Barnett's book on originalism. But in that article, she criticized Chief Justice Roberts' opinion in the Affordable Care Act case, Sebelius, as really stretching and going beyond what she thought was a plausible interpretation of the Affordable Care Act in reading the provision, the individual mandate, and its penalty as a kind of tax. She said he stretched the meaning of the statute too far, and that wasn't a plausible textualist interpretation. So she suggested that Chief Justice Roberts, was not a textualist, and that she would be a textualist. And of course, she was peppered with a lot of questions about the Affordable Care Act. But I think many scholars have suggested that even if she's confirmed, that doesn't necessarily mean that she's going to rule that in the current case before the Supreme Court, that she's going to rule that that the entire Affordable Care Act needs to be struck down. And she characterized the case as also being about severability. Severability, it's, you know, if she's going to be a textualist and she's going to read it according to the intent of those who wrote the Affordable Care Act, presumably they intended provisions that would be struck down as unconstitutional be severed from the provisions that could be upheld as constitutional. So it's not so clear what she's going to rule, if anything, in the Affordable Care Act case, but it does, of course, connect to her textualist philosophy as well as her originalist philosophy. Professor Coles, did you want to comment on Professor Little's remarks as well?
Well, just two thoughts. One, I think that we'll find with an originalist Supreme Court that there's less that Congress can undo that you may think. I don't think the Voting Rights Act can be restored. I think they are waiting to take the next step on the Voting Rights Act to say that it's a violation of state sovereignty. So I think they are anxious to take what that weaponized First Amendment that they have, that they used in Janus to strike down, contribution laws for places represented by unions, that they used in Becerra to say, while it may be okay for the state to say things to women to discourage them from deciding to terminate a pregnancy, it is not okay to tell somebody that they have to let women know that there are other alternatives available to them. I think the weaponized First Amendment at the hands of the current court and an originalist court is likely to be very little help. And, look, I think there are four great issues in individual rights that the court really did do some good things with in the 60s and partly in the 70s. Race, gender, rights in the criminal justice system, and dissent. I think the First Amendment has been turned into a weapon of the rich, and that we can't expect great protection for dissent from that. I think on race and gender, I just as soon keep the court out of it at this point. I think we do much better with the political branches than we do. And on dissent, when you go back to the 1960s, the cultural commitment we have to the principles of the First Amendment, I don't think was built into the culture and ingrained. I think it is now. I think post the Vietnam War, I think post the tumult of the 60s, it really is ingrained. And honestly, today, I trust the populace in more places to protect that than I trust the Supreme Court.
So I wanted to leave room for questions and comments from those of you out there. We would welcome your questions. You can use the raise hand function to raise your hand if you'd like to ask a question. And you can also use the chat. And I see that there's already one question in the chat. Professor Richard Boswell is asking, if we are extrapolating too much from Judge Barrett's Seventh Circuit opinions, a circuit judge is driven by circuit law as well as Supreme Court precedent. Can you comment to that? Did anybody want to comment to?
Radhika, let me use Professor Boswell's great question as a way of responding a little bit to things you and Matt said. First, I can't wait to see the fight between Justice Barrett and Justice Gorsuch on textualism, because of course Justice Gorsuch, the great textualist, found that the sex discrimination federal statute applied to gender and sexual orientation discrimination and transgender discrimination. And he said, this is all just pure textualism, even though that was not the intent of the people, perhaps, who wrote the law in 1964. So maybe they'll have a big fight. Textualism is, as you put it, a philosophy which is manipulable. We always look at the words of a statute of the Constitution before we answer a question, but we don't stop there. And neither will she. And I also think the ACA case, I would be astounded if they were to hold that the individual mandate, constitutional or unconstitutional, isn't severable. There is a severability phrase section in the statute which says if you strike one thing down, the rest should be severed. there isn't any doubt in my mind, particularly since the individual mandate is now raising no revenue because they zeroed it out, that they would have adopted the whole act without the mandate. Now, whether they would today is a whole different question. I agree with Justice Cole, Professor Cole, but I want to make
I appreciate the promotion.
I want to make you a justice, and I'll tell you why. Because maybe you don't trust the court today because we don't like where the court is. But when Justice Coles is on the court, then maybe we'll trust the court. In other words, the court is an institution that is capable of doing very powerful things. It is a third branch of the government. It's an important, separate, and independent branch of the government. And I'm prepared to have some faith in it. But you're right that for the next how many years, we may not have the right folks there. And this is one reason why the court expansion idea does not strike me as threatening to the institution, because it would be a direct response to the Garland broken promise. It would not be a historical precedent to always do this when you win a new administration. It would be to address this one particular incident. Could you control it that way? I don't know. Anyway, Voting Rights Act, I read the Shelby County as dependent on Congress did not use current data. And if Congress were to use current data and reenact the Voting Rights Act, I don't think the court would strike it down. At least Justice Roberts wouldn't strike it down.
It's the second part of what you said. I worked on Shelby County. If you read his opinion closely, he says, we're reserving the whole question of whether, if it had been based on current data, this would represent too great an incursion on states' rights. And the data he wants, by the way, is not data that suppression of Black votes is still a problem. The data he wants is that it's a worse problem in South Carolina than it is in Ohio. If he doesn't get that data, he's not going to agree to it.
Well, yeah, we'll fight the Voting Rights Act when it comes back for reenactment.
If ever.
Professor Boswell's question, yes, Richard, I think you're right that you can't read too much into what someone has done in cases where precedent in their own circuit binds them. You also can't read so much into what they've done where Supreme Court precedent has been read to bind them. And this is why Supreme Court justices, I think, there have been justices who've said this, when they confront these questions at the Supreme Court level, and there isn't a further check on them, there isn't a court of review, there's just a court of public opinion and peer acknowledgement, they suddenly find that they may not feel quite as strongly as they thought they did somewhere, or that they feel more strongly in one direction or another. But I think you're right. I think that's the problem. One of the many problems with the nomination process, as Justice Coles said, and I'm going to call him Justice Coles the rest of the panel, is that you can't learn anything about these nominees in these hearings. They are a waste of time for anything other than we get to see them on TV and we get to meet the members of their family. I see another question in the chat. Radhika, you go ahead.
Hands too.
Excellent. We have 2 hands raised. So let's go to Omar, and then we've got Talia.
Good afternoon, professors. The politicization of the court seems to be a reflection of the polarization of the country, and specifically the polarization of the Senate. So the Senate of today is not the Senate of Webster and Clay, where it was more dynamic and these great compromises were made. So I'm wondering if, in your opinion, you think that the erosion of the patrician character of the Senate was a mistake?
No.
I think compromises are possible without keeping the institution patrician. And I think functioning is possible. Part of the problem, I think, is that Congress has abdicated power to the executive branch steadily over the last, really there was a brief period after Watergate when it reined in the executive some, but I think since then they've been steadily ceding power to the executive branch. And that keeps getting validated by a federal court system that has been getting more and more conservative through the 80s that likes strong executives and doesn't like the chaos of Congress, but that's not the design. So no, I don't think it should be more patrician. And I think the fact, we shouldn't get upset that it's somewhat dysfunctional. It was designed to be.
And
No,
actually, that connects to a question in the chat. Professor Benjamin Bloom suggested, he said, you suggested changing SCOTUS jurisdiction. Matt Coles, I think that was directed to you. And court expansion, Rory suggested this as well, as paths forward after the election, if and when Amy Coney Barrett is confirmed. And Professor Benjamin Bloom asks, are there less polarizing solutions you can think of that would restore the court's legitimacy and not invite reversal or retaliation by the next Republican administration?
Well, I'd say I picked the notion of limiting the court's ability to declare statutes unconstitutional because I think it is less partisan and in most other modern democracies, either courts can't do what our court does at all, or there is a limiting principle like this. There's a limiting principle like this in Canada. There's limiting principles in Great Britain. And again, it cuts both ways, right? The left has used the federal courts at least as much as the right has. So I think it cuts both ways. I do think expansion just leads to escalation. If we take the court up to 13 to create a solid progressive majority, then when the Republicans get control of both houses again, they'll take it up and have it sit in panels or whatever. I think the proposals to stagger terms, to create terms, or to rotate I think all of those need a constitutional amendment. I really went to the upping the jurisdiction to get away from real court stripping, which says you can't hear this case, you can't hear that kind of case, to get away from real court stripping and to get away from things that I thought would just invite retaliation.
And let me just say, Omar's question is a good one, but I think we have a bit of a mythic image of this Congress. I mean, Congress was a pretty rough and tumble place in the 19th century. And there were members of the House clubbing each other to death, not quite, on the floor of the House. And, and the Civil War, in some sense, was a result of the dysfunctional Senate. Not obviously, there were lots of other forces at work. And so they developed all these rules on how to be a little more friendly to each other and how to get things done with compromise. I think that has broken down in the last few years. I do think if the election were to go in favor of a Democratic Senate now, you might see a little bit less aggressive partisanship. And this is in response to Professor Blum. I mean, I believe that my advice or my desire to go slower and to not change everything on the second day of the administration is a way to see if it can be worked out in a less confrontational way. Let the Solicitor General manipulate the docket to some extent. Let the executive branch moot various policies or try to react to various policies. Let people in Congress reach across the aisle maybe and pass some actual legislation on a bipartisan basis. And in some sense, ask the court, let the judiciary decide for itself that it should back off a little bit, that maybe it's been going too aggressively. I mean, the Becerra case that Professor Coles mentioned, it's just it's just wrong. It's just crazy in so many ways. And let them recognize their own errors is what I would say. So anyway, I'm sorry, we should go to the question from the student.
Yes, Talia.
Thank you so much to all the professors and everyone here for putting this event on. My question pertains to some concerns that I have about the court's ability to overstep its power with respect to any election-related legal disputes that might arise after the November 3rd presidential election. And although Justice Kennedy wrote the opinion in Bush v. Gore, famed originalist Justice Scalia wrote a concurrence in which he supported the court's move to essentially pull precedent out of nowhere to install George Bush as the next president of the United States. And I'm sure you can tell, I'm of the political opinion that originalism, it sounds nice in practice, but I don't think it actually materially exists uniformly in practice. So I'd love to get your thoughts on the plausibility of the court with Judge Barrett's help, assuming she's confirmed, in that they would sort of pull something similar to what happened in Bush v. Gore if, a comparable legal dispute were to arise, say with absentee ballots after the election.
Wonderful question, Talia. And I just wanted to comment here that Judge Barrett was peppered with questions about whether she would recuse herself. And I read an editorial by former United States Court of Appeals for the Fourth Circuit Judge Ludig, who is not by any means a liberal. He was a former law clerk to Justice Powell, and he's considered to be quite conservative. And he was writing an editorial saying that under current Supreme Court precedent, Judge Barrett should recuse herself, that she would have to recuse herself because, and I cannot remember the name of the case now, but of the recent case that was decided about a judge who should have recused himself, the court held in a case where there was a perceived conflict of interest. And so he was making the argument that this running so close in terms of timing, her confirmation, her appointment by President Trump and her confirmation just days before the election really seemed to create a clear conflict of interest under the meaning of that very recent Supreme Court precedent, which he said some of the justices in that case said the Supreme Court would later come to regret. So I think it's pretty interesting that Ludig, was it Ludig, I think? Who wrote that editorial, was arguing for recusal, that Judge Barrett would be obliged to recuse herself under current Supreme Court precedent. But of course, Supreme Court justices are the arbiters themselves of when they need to recuse. And so it'd be interesting to see how she interprets the recusal rules and whether she would recuse. And if she does recuse, and if you have a split court, then what happens, right? And we've got a 4-4 decision. So it's really, we live in interesting times for constitutional law and constitutional lawyers. Sometimes I wish we didn't live in such interesting times, but all of this raises a lot of very troubling questions.
Can I just say, I don't think you can put too much faith in this recusal idea. Ludig said that she should consider under Caperton whether to recuse. He also said he thought Caperton was wrongly decided. I think he was speaking actually silently to Justice Barrett, saying, you should get rid of this Caperton case. Ludig clerked for Scalia, I believe, on the Court of Appeals. I may be wrong. And he's no friend of a certain side. But more importantly, Scalia was the champion of non-recusal. Remember the Cheney duck hunting incident where he wrote a 17-page opinion saying, here's why I'm not recusing. Sort of like he protested too much. But can I just say, this is where the pandemic actually really hurts. We're all hurting from this remote isolation. When you're one of 9 justices, when Amy Coney Barrett gets up there to that building and is one of those 9 people, and Justice Scalia is not there to tell her what to do, his spirit lurks perhaps, you're going to have people talking to her. And traditionally, the Chief Justice actually speaks to the newest justice in an informal way. And there's a lot that happens behind closed doors. Justice Kagan is a remarkably persuasive and charming person. So are some of the other justices. And I think the feeling among some of the justices still today that Bush versus Gore was a huge mistake, and that it would have been better to let it play out in the rough and tumble of the states and the political process. Bush might still have ended up to be president that way. There's no real guarantee how that would have come if it had gone to the House of Representatives. But I think now they're not going to be in the building. They're not going to have these closed door discussions as they might have. I think it's a shame, right? Chief Justice Warren persuaded the court to be unanimous in Brown when Stanley Reed was determined to issue a dissent. There was a draft dissent out there because he went to him privately and sort of chummed him up. But I have some belief that Roberts and Kagan together will tamp down the excesses of a new justice, although we'll see.
Talia, to just quickly answer your question about the election, I mean, I think what we should all hope for most is whichever way it goes, that it goes very strongly, because that will greatly reduce the possibility. I think the most likely post-election challenge, nobody could have predicted Florida, and it'd be a little hard to predict here, but the Pennsylvania case that they just split 4-4 on, the core argument that the Republicans were making was that under the Elections Clause, Congress had set the first Tuesday after the first Monday in November as election day, and that if you're counting ballots that came in after that, it's in violation of that statute. It's not election day. I would ordinarily have thought that was kind of a non-starter, because the other part of the Elections Clause gives the states the power to determine. Congress didn't really say what it meant by election day, and we have a long tradition in various states of counting absentee ballots that arrive afterwards as long as they're postmarked. But the fact that it's split 4-4 is a little bit scary.
Yes, that was
one
really
of the arguments in that case, I believe, was that the legislature had said they would not extend this, and it was the Pennsylvania Supreme Court that announced that it would be extended. And the argument was, it's the legislature that is given the constitutional authority to determine the manner of election, blah, blah, blah.
It was both. It was that and the act of Congress. There were two different arguments.
So, who knows where these challenges will go. And Matt, you've got to be right. We just got to hope that this is so clear that Pennsylvania becomes irrelevant.
There's another question in the chat that Professor Boswell raises that seems connected.
There's one ahead of him.
There's one by David Pye, which was ahead of it, yeah?
David Pye is ahead of it, yeah.
So you want to go to David Pye? So David Pye is asking, assuming SCOTUS expansion is on the table, can the court itself impose rules, creating an en banc panel that's randomly drawn in an effort to depoliticize the court? For example, if we have 15 justices, can the court say 9 justices will be randomly drawn to hear each case, such that litigants cannot predict how the court will rule if on such an issue? Now, I believe that the Supreme Court can control its own, the way in which it sits. So it should be able to do that. But Professor Coles, you're a proceduralist.
Well, absent an act of Congress saying they can't, I think they should be able to do that. I will say, that the court seems more and more in love with whatever's been done historically, right? The court now says that, prominent evidence that a statute is unconstitutional is that we haven't done it before, right? And so I'd be a little worried that there'd be a strong push from the chief not to do that, saying we haven't operated that way before and we shouldn't.
But it's
a good idea.
Yeah, it's a really good idea. And it doesn't seem as if something that would be beyond the purview of the court or would require an amendment or would require any such kind of revision.
Professor Boswell now asks the heart of the question, right? He goes right to the heart. Do we see the elevation of Justice Barrett as a possible opening of the door to an activist conservative court?
Door's wide open.
Yes,
it was open before she got there.
She says
it's a rhetorical question, Professor Boswell.
To give a serious answer to that, I mean, if you just look at what they've taken up for the next term, I'm thinking for a second of Fulton against the city of Philadelphia, right? I think the free exercise clause should be more vigorous than it is today. I think it's almost a second-rate constitutional right. But I think it's clear that that Justice Alito and Justice Thomas and quite possibly Justice Kavanaugh and Justice Gorsuch want to make it into the strongest constitutional right far and away. Again, to just go back to what I was describing as the weaponizing of the speech portions of the First Amendment. If Janus, the Union case, is not an activist conservative court, I don't know what it is. I think it's Lochner. Lochner's come back, but it's mutated from the Due Process Clause to the First Amendment, and anything anybody doesn't agree with, if it runs against the right kind of moneyed interests, is going to be unconstitutional.
I shouldn't say Justice Barrett, Judge Barrett, soon to be Justice Barrett, actually almost says as much in her constitutional commentary review of Randy Barnett's book on originalism. She basically says that when originalism conflicts with our current precedent, you go with originalism, you overrule contradictory cases. So she says Chief Justice Roberts believes in judicial restraint, but she thinks that if a case is wrong under the philosophy of originalism, it needs to be overruled because the Constitution is supreme. I've got my little pocket copy of the Constitution. That is supreme, and any case that contradicts the original meaning of this document needs to be thrown into the garbage. So
get rid of that radical Gibbons against Ogden and go back to the way the Commerce Clause was meant to be.
On the other hand, she doesn't say that Lochner, she doesn't say, the whole court's episode with Lochner doctrine, and we now think that Lochner is no longer good law and the Supreme Court was wrong. She doesn't disavow the court's disavowal of Lochner doctrine in that book review. And she suggests that perhaps we should still apply rational basis review to economic legislation. At least she doesn't seem to see that as contradicting original intent.
Except when Congress does it. And then in the ACA, we'll take a much more aggressive look.
I hate to be Pollyanna here, but the force of precedent actually does mean something, I believe, to all the justices. It is hard to imagine a justice taking on the fifth vote to overrule Brown versus Board of Education.
Oh, yeah.
But I mean, to say that's consistent with original intent is to ignore the racist origins of all of the Constitution, including the 14th Amendment, in my opinion. So what I would say is
citizenship.
Even Justice Barrett believes that there are super precedents. She's just unwilling to say exactly which ones, and the favorite target of the day happens to be Roe versus Wade. And I think it's much easier to say things when you're, frankly, a law professor writing in constitutional commentary than when you are sitting there as the fifth vote and everybody around the table is looking at you. How do you vote? Strike this up or down? I'm not saying that she's going to be an angel of moderation. I really don't believe that. I believe she will be joining Gorsuch and Alito and Thomas. I'm not convinced that Kavanaugh is part of that cabal. He's departed from Gorsuch in a couple of cases, interestingly enough. Roberts seems to have said history is more important to him than popular opinion. But is it going to be an activist conservative court? Yes, it's going to be an activist conservative court. I mean, I don't know how anybody could take issue with that idea. But is it going to pull the legs out of the foundation of everything that we have taught in law school? I don't think so. And I'm willing to take it easy, use executive branch manipulation of the docket and of laws and congressional manipulation of laws to try to keep the court away from certain principles.
And that's great. I think I agree with you, Rory, that nobody wants to be the fifth vote. But unfortunately, at this point, if Justice Barrett is confirmed as a justice, we'll have 6 votes. So nobody will be the fifth. You'll have, because Roberts isn't going to want to be all by himself, joining the other 3 dissenters, presumably, in a case that overrules Roe versus Wade. So at that point, if you've got 6 votes, I think you're going to get rid of some precedent. Now, some people have suggested, and Matt Coles was making this argument earlier, that maybe we've relied too much upon the courts. And some scholars have suggested that that has resulted in democratic debilitation, really a weakening of our democracy and our democratic process. So maybe the solution here, at least part of the solution, is to reinvigorate our democracy and our democratic process and not rely so much upon the courts as an institution to bring about social change. Because if they're going to bring about social change, it's not necessarily going to be the kind of social change that we might want to see. And perhaps we need to look to other branches of government.
Could I just add a piece to that, Radhika? And some of this comes from maybe a parochial view of having worked in LGBT rights for so long. But working in LGBT rights not long after I graduated from Hastings, so back in the ancient late 70s, we were very wary about going to courts. But in 1986, right, the Supreme Court slammed the door of the federal courts in Bowers against Hardwick. And it wasn't the holding of Bowers against Hardwick that did that. It was the contemptuous tone of the opinion that I think conveyed to all the lower federal courts, do not take these people seriously or their claims of civil rights seriously. And I think that was, in the long view of things, one of the best things that happened to the LGBT rights movement, because it said it to us effectively: if you want to get anywhere, you've got to learn how to have to play in the political game. Now, I do think the courts, once the other side, the forces of darkness, as I like to think of them, tried to change the rules and start amending state constitutions to take us out of the political process, we did rely on federal courts to get back into the game. And I think when you look at the civil rights movement, you know, working on Romer, which you mentioned earlier, because I was working at the ACLU, I was tasked with looking at potential First Amendment arguments as we were going to do the preliminary injunction. And I wound up reading all these cases from the 50s and 60s in the civil rights movement, and I became convinced that most of the great things the Supreme Court did for the civil rights movement were not equal protection decisions about race. They were First Amendment decisions that kept Black people from being shut out of the political process. And I think even this court, even a very conservative court, we will still be able to use that way. And that's, in many ways, my recommendation to movement people is: make yourself stronger politically, use the courts defensively.
Can I also bring this back to something else that Professor Coles said? Justice Coles, as I like to think of him.
Throwing bombs, Rory.
No, this is, I would hesitate right now if the Senate were to swing back to Democratic and the president were Democratic. I would hold off on the idea that you should not vote for people who withhold their opinion on central issues. I would reserve that idea for the next set of Amy Coney Barrett's.
No, wait. I didn't mean reserve their opinion on central issues. If she doesn't want to say how she thinks abortion should play under the Equal Protection Clause, I'm with her all the way on that. What I'm not with her on is when she says, well, I can't tell you how we should decide what cases should get strict scrutiny and what cases should get rational basis. I can't tell you whether I'm a Slaughterhouse thinker or I'm a Carolyn Products footnote 4 thinker. I think I'm entitled to know that as a senator. Let's put me in the Senate today.
Well, and I wonder how many nominees would even understand the question if you put it that way.
Oh, Lord. All of my con law all of our constitutional law students do.
Remember, the history of the Supreme Court has not been to nominate legal academics or justices necessarily, but it has been to nominate politicians who have buddied up to a president in one way or another. Some of whom have turned out to be pretty good justices, and others
great
failures. Maybe there should be some return to that as well. Maybe the problem with academics on the Supreme Court or people who had academic careers and then judges on courts of appeal is, one, they have not labored very long in the field of actual real person law and litigation. They are not familiar with Amy Coney Barrett has surfed at the top of the profession all the way through and hasn't been on the ground. That's one. And two, we train lawyers to be able to argue any position and to rationalize any view and to semantically manipulate the law in order to reach results. I'm not sure that's good training to be a Supreme Court justice. Maybe it's better to be, I don't know, Hugo Black, who was the people's representative of the poor from Alabama.
I mean, look, just to add to that, the truth, I think, is there's no one set of qualifications. You know, all of the Supreme Court now is filled with people who were Court of Appeals judges before that, and often district court judges. And I think that's a loss. I think having Earl Warren, I think having Sandra O'Connor, who were people who understood politics on the court. Bill Brennan was a backroom Democratic politician from New Jersey who understood how to put his arm around somebody's shoulder, right? He was just But I think it's a great loss when we say, well, you got to have been on the Court of Appeals. You got to have a lot of judicial experience. I agree with that.
Yes,
Get some litigators in there.
and Amy Coney Barrett will be replacing somebody who was not just a legal academic, RBG, but also litigated cases, real world cases, and really understood the human dimensions of the law. And part of what seems so cynical about her appointment as a replacement is that you're kind of saying, well, all women are the same, and one woman retired, one woman passed away, we're going to replace her with another woman. So people should be happy. And RBG stood for more, so much more. And to replace her with Amy Coney Barrett, well, it looks a lot like Clarence Thomas replacing Thurgood Marshall. And I was there and I saw the political cartoons that Justice Thurgood Marshall had on his wall about Clarence Thomas. And he clearly felt very upset that he was being replaced at that time, that he retired and was being replaced by Clarence Thomas, who was viewed as a substitute for him simply because he was an African American, but totally did not have Thurgood Marshall's experience. 29 out of 32 cases argued and won before the US Supreme Court. And RBG, 5 out of 6 cases argued and won before the US Supreme Court. What a life of experience that we are now seeing Judge Barrett as a successor. Well,
I think we should take people with a less grand one-loss record, though.
Yes.
Just trying to keep my appointment alive.
Okay. Well, we've got actually one question from YouTube. Can the panelists talk about gay marriage and what it will look like with this new court? I know that there have been rumblings from Justices Thomas and Alito about perhaps the court should revisit Obergefell. So a YouTube question. Matt?
I don't think the court is going to revisit Obergefell because I think people are going to have very little taste for that. I mean, the thing is, same-sex marriage was a huge controversy until it happened. And now it is far, far less controversial. And I don't think the court's going to want to thrust itself into the middle of that by yanking it away. On the other hand, I think, as I said, that I think Justice Alito and maybe 5 people with a new appointment on the court are anxious to really weaponize the free exercise clause and essentially to say in the name of the free exercise clause, it's not about your ability to worship without fetters. It's about your ability to essentially discriminate against anyone, an employee, a tenant, really anybody, if you don't like them because of your religious views. And I sadly think that's the direction in which we're going. So things like Masterpiece Cake Shop or the cases that went along with that, I think the free exercise clause is going to get energized in a way that is going to make it's going to make the baker win in Masterpiece Cake Shop and in much more consequential situations where employers might say, for example, we're not going to extend the health plan to people who are in same-sex relationships because we object to it on religious grounds, and that goes for corporations as well as it goes for individuals. You know, I think the answer to that is largely going to be in state law.
And even Pope Francis has come out in favor of same-sex civil unions, it seems unlikely that the US Supreme Court is going to take away a right that's already been extended to so many couples. But I agree with you that probably the action is going to be with respect to discrimination, claims of discrimination based upon religious freedom.
Since we have only 1 minute left, Matt, I want your full opinion on the new congressional statute from the Democratic Congress, which will say it shall be a violation of law to discriminate against anyone on the basis of sexual orientation or sexuality, and religious objections shall be ignored in that process.
Oh, well, I mean, I think the court will strike that down. Don't you?
Which court?
This one.
I don't know what this one looks like yet. I'm holding my breath until that gavel comes down on the vote on the floor. I'm still hopeful that things can happen in this world that we don't expect.
Well, wonderful. Thank you all for being here, and I hope that your questions were answered. Thank you to my colleagues. As always, I learned so much from you. So we're out of
Thank you,
time.
Radhika. Rory, terrific. Always fun.
Thanks, everybody.